little bit a legal and techno related topic, and I'm very much thankful to all GDG and the WTM community to inviting me here. And it's my pleasure. I'm talking on the International Women's Day. As a woman, it's always a pleasure and honor to talk on that day on your specific topic. So basically the topic is related to the intellectual property rights and the AI. As the, I think all of the audience are from the tech background, so that's why I have incorporated the intellectual property with the AI and how it will affect the innovate to impact. So whatever you are inventing or innovating or doing any research in that, how it will create the impact in the form of the financial perspective, in the form of the society perspective, how it will create the impact on that. That will touch upon that. Start with the basics about the intellectual property rights. So this is just a little brief info about myself. That is, I am the president of the Gujarat State Intellectual Property Council of the Women's Chamber, and I am the registered Indian patent agent under the DPIIT Government of India, and I am the founder and CEO of my own law consultancy. I am a woman entrepreneur since last 3 years, and we have filed almost more than 170 patents, and out of that almost 70 patents has been granted. So almost we can predict a 1/3 ratio within that 3 years has been achieved. So this is the flow of the presentation. First, this is the main one, introduction about the intellectual property. As you all are from the tech background, so you need the details, basics about the intellectual property rights. Then how the importance of the intellectual property rights interconnection with the AI, and what is the scenario of intellectual property rights and AI into the India, because as you all know about that, as such IP rights or the patents is not allowed for the softwares. So how we can protect your intellectual property in the form of the softwares in the India, that is scenario we need to touch upon that. So as we can see that intellectual property rights, if we are breaking down this word, it's an intellectual property and the rights, right? So first we are taking the intellectual property. So basically very common question to all of you, that what is the property? Anyone can answer for it. Yeah, please.
Something that we own.
Yeah, good. So can you give more insight that what is the different types of the property? Any other also can give answer for that. Yeah, good, very good. So there are basically two types. One is the tangible, another one is the intangible. So tangible means you can touch, you can feel those things. If you have a house, you can touch that, and you can feel that. If you have a jewelry or your own clothes, you can wear and you can feel that, okay, this is mine, right? Those are the things which you can touch. That includes all the physical properties which comes under the tangible properties. Another is the intangible property. Indirectly or directly you cannot touch those things, but ultimately it's your property. Like any creation of your mind, those comes under the intangible property. If someone having knowledge that they are writing the poem, so it's actually a property of that person. Or they are doing some research, that is also actually a property of those person. So any kind of the ideas, creation or any thought which comes from your mind, which is a unique one, it's become a property for you. If you want to convert it as a property. Otherwise you write down the poem, you post it into the social media and it remains as it is. But if you can protect those things, then it become a property for you, because whatever you have your automobile or the vehicle, so you have a document for that. Similarly, if you have a house, you have a document for that. So for intangible property also you need some strong document for that. So for that I am here to explain you about the intellectual property rights. So basically intellectual property is a kind of the intangible property which includes the creation of the human intellect or human mind. Anything which comes from our mind, that included into the intangible property and the intellectual properties. So now we have come to the second part of that word, intellectual property rights. So intellectual property rights means something will be the legal or the documented form which gives you the rights on your property. So, intellectual property rights is the legal protection or the legal procedure. By that way, you can protect your intellectual property for your any kind of the original works or your research work or whatever comes from your mind. Yes. So, intellectual property, basically by that picture you can understand that how your intellectual property into the secure hands. If you are protecting your intellectual property or your intangible property by the IPR, then only it will be in the secure hand. Otherwise, someone has write down the poem, he or she has posted on some social media, some other person may do some changes in that and they come up with a new poem, right? So you cannot take any action against that person because you don't have that rights, you don't have that document to prove that okay, this is your rights. So if you are protecting your intellectual property by the intellectual property, then only you can enjoy the monopoly of your creations. So these are the few types for the intellectual property rights: patents, industrial designs, trademark, copyrights, trade secrets, geographical indications, semiconductor integrated circuit layout designs, plant varieties and breeders' rights. So these are the 8 types in which whatever thoughts come in your mind, you can put into these categories and you can enjoy your monopoly and the monetary rights out of this intellectual property. So basically patents, anyone have an idea about the patent? What do you mean by the patent? Anyone? Yeah, please. Sorry?
Owning something.
Owning something in elaborate way? Sorry.
Like if I have invented something, like a bulb, then I need to file it like I have invented this. So owning is file.
So in very basic scenario, if I can say any kind of the research work or technology related work, if you want to protect that, you can protect by the way of the patents. As such, all the IPRs having equal rights, but patents having in the form of the executing, we can say it having more rights because it includes each and every concepts or the technological things into that. Other than that, other parts includes some includes the design, some includes the brand name, some includes other things. But in the patent, you can give the each and every details about your invention. So that's why it's a stronger one as compared to the other intellectual properties. Coming to the industrial designs, so let's for example, this is one bottle, right? If you can see any other bottle which having different kind of the shape in that. Or by the way, looking this bottle, if you can see the Bisleri bottle, they having a almost triangle shape nowadays in the smaller bottles. So both the bottles having used for the same purpose, for the just water drinking, but both having a different shape. So those kind of the shapes can be, or the designs can be protected by the way of the industrial designs. If you can see, mainly in the summers, many of the cold drink bottles designs has been changed because to avoid the copying. So those things can be protected by the design, and to avoid the copying and to take the legal action, both are the different things. They are come up with the new designs. That's why they are avoiding the copying. But some person who copying the same designs, then how you will take the legal action on them? So for that, this comes into the picture, the intellectual property. If you have a rights for that, then only you can speak. Otherwise, if you don't have a rights, how you can say that this is, you are copying my product? Where is the proof for that or the evidence for that? Then coming to the trademark, I think everyone knows about that. What is the trademark? Anyone can give very the single line answer? Only logo? Design in the form?
Any tagline? Process. Tagline.
Okay. Any other?
Tagline.
Yeah, good. So basically trademark is the kind of the brand brand name. We can say it may be a name or a logo or a tagline, right? So that can be covered under the trademark. We'll see in detail also in upcoming slides, but this is just the overview for all the IPR. Then coming to the copyright. Anyone have an idea about the copyright? Actually this is related to your field, the technological field. Yeah, but in which form? Yeah, please.
मैम जैसे एक मूवी बनाई है तो वो मूवी की कॉपीराइट मेरे पास है, तो वो मूवी को अगर किसी और को कॉपी करना है तो उसको मुझसे परमिशन लेना पड़ेगा। एक भी अगर क्लिप को उनको लेना है तो उनको मुझसे परमिशन लेना पड़ेगा, वरना मैं उनके ऊपर कॉपीराइट का केस कर सकती हूँ।
Okay, very good, very good. Well done.
उसका entire content, whatever, suppose I wanted to utilize some of the part, I need to take the permission, or else I have to give the training.
Kind of the literally work you are telling about. Literally means any of the write-up things are there from which of you want to copy the things, then you need to do.
Same in song. Let's say if somebody written the song, if I want to utilize, because Facebook it sometimes, if you utilize the same song, there issue the copyright.
Exactly. So the copyright is a very common in the our community. We can say community means it's a very well-known IPR. So everyone can knows about that because it's mainly related to the musical or cinematography or the artistic work or the literary work. So it's related to the everyone's life. So it's comparatively a common one. Then the trade secrets. As the name suggests, it's a kind of some secret, right? So whatever you have, you can keep. It's in the form. This is also related to your field. Whatever you have write down in the code or any AI based any kind of the product is there. So those kind of the things or any kind of this which you want to keep as a secret, because in the above side if you can see any of the IPR having a limited period of rights. If a patent we can say 20 years you can enjoy your monopoly. After that it will be open for all. For the trademark also the 10 years will be there, then you can renew the things for the designs also. But in the trade secret, till you keep as a secret, it will be remains as a trade secret. So many a times bigger companies choosing these one, or in case in the technological field as the patent is not allowed as of now in the India, so you can use this trade secret as a IPR tool for that. Then geographical indication, as word suggests, is geographical, is related to the some geographical origins. So in the Gujarat, if we can show the Patana Patoda, Jamnagar's Banni, then Gir Kesar mangoes, Darjeeling tea. So all are specifically related to this geographical origins. If you can plant a mango over here, it will not give as good taste as the Kesar Gir mango, right? Because their climate conditions or whatever the earth or the soil related properties are over there, it's not here. So based on that also the protection is given to them. Many last year mainly patent office or we can say the IPR office is focusing on the geographical indications to just give the rights to the community which are working on that, because they don't have a science background, they don't have idea about that, but they are since long they are working and they are come up with this. The Patana Patoda, they are not the educated person, but they are come up with a very good thing. So for them this kind of the IPR is there. They can enjoy, they can register the whole community. Here the only single person cannot apply for that. Community will be apply over here, and by that way they can enjoy the monopoly. Then the semiconductor integrated circuit layout designs, any kind of the new PCB will be there or the any cheap design will be there, you can protect under this kind of the act. Then any plant varieties, very in the earlier time only the green or the white flowers, cauliflower is there, but nowadays the purple, then tomatoes also in the different colors are coming, right? So by somehow they are doing some invention in that, and that's why the colorful vegetables and fruits are coming. So those things can be protected by the way of the plant variety. So whatever thing be protected by the different IPRs, this cannot be protected by the patents. So if you are come up with any colored vegetables over there, so those cannot be patented by the patents, because those are already the new type is given for that particular invention. So if we are coming to the branding and trademark, that is most commonly used in the we can say the marketplaces. Mostly people are using this IPR. So trademark is a sign, it's a kind of the sign which distinguishes the goods as well as the services from the one to other. Let's for example this bottle having this name of the Horizon, right? But whenever we are going to purchase the mineral water, we are always telling that please give me a Bisleri bottle, because it's create a brand value in our mind that this is Bisleri means it's a pure water. Other than that, no other bottles will give that kind of the things. So basically to create the brand value, also for that we need to file something or we have that document for that. So for that the IPR is the trademark. It's a kind of the visiting card, we can say, whenever we are going to someone and we are giving a visiting card. Similarly, this trademark act act as a visiting card for that. So from the starting of your day to the end of day, if you can look into your products, whichever you are using, from starting from the brush to the last your blanket, you can check it out whether if it's a branded, you can show that these two kind of the symbols are there. One is the TM and another one is the R. Mostly the R, because the registered trademark will be there. So TM means it's unregistered, or we can say the person has applied for that but is still in under process. So till the process registration, that person can use the TM. So they have applied for the trademark, and the R is related to the registered trademark. So now from the tomorrow you can just check it out, whatever product you are using, whether it's for that trademark is applied or not. So actually the IPR is surrounded you throughout the day. If you can check it out, if you are listening any of the music, then also on that the copyright is applied for that. If you are using any of the product, on that the trademark or the patent is applied, right? For the Coca-Cola, for the trade secret, Coca-Cola is the best example for that. So if you are drinking that, so you can also utilizing their IP rights, we can say. So basically the IP is around us, but lack of knowledge, we don't know whether what is the IP and how we can utilize those things. So these are few examples. As Adidas, if we can see the R is there, means it's the registered trademark in the Nestle, in the McD logo, or the Coca-Cola. Everywhere you can see all the big companies, they are applying for the trademark to just create the brand value into the society. Then coming to the copyright. So copyright is kind of the rights. It's a legal right only given to the creator who has created something. Either it's a poem or a book or a music or song lyrics or any movie they have scripted, or in case of the computer generated work, it may be a software, AI based things, ML based thing, whatever related to it may be a website, that also comes under the copyrights. So these are few examples that you can see in the Twitter. It's the C is the symbol for the copyright. So as they have applied for the copyright and copyright registered the C, they can write down the C. Some of the websites they have write down the C. So in mainly in case of the tech people, for any kind of the computer generated work, you can apply for the copyright and you can take a benefit out of that.
So I have one question.
Yeah, please.
So most of the time we as a developer, what we do is we don't apply for copyright. We can write C at the current year. Is it valid or not?
Is it valid for copyright?
But how? Because I'm not applying it. I'm just saying that it is.
But in the form of the computer generated work, you have a proof that from the this time I am using this or somehow. In case of the literary work, the poem or the any kind of the book writing, in that you have to apply it because you cannot prove. But in your case, you can prove because it's already on the computer generated work. It's maybe a website or any code over there. So indirectly, it's your property. So you are originator of that property, and that's why copyright is given to that.
Because all the other people that you mentioned, you need to go and apply for the legal.
Because for that proof is required. In this case, you have already you have a proof for that.
So that means who are sitting in this room as a developer, whatever the code they have written, they have the copyright of their own because they can be written by themselves.
Yes, they can. But it's better to apply for the copyright. Because whenever you are in the legal battle or somehow, so at that time some legal document is required.
So for example, like I am working for one company, okay? And now I'm switching that company. So can I say that okay, this is my IP? Because
Yes, you can. Because this is given to the originator or the creator. So the whoever is using, but that is related to the terms and conditions of that company. If in your employment agreement, if they have write down that whatever you are doing over here, it's our property, then you cannot take any, or you cannot say, you as a creator you can take moral rights, we can say, this is my property. But out of that you cannot generate the revenue or the money out of that. So with the intellectual property, two rights are there. One is the moral rights and another is the monetary rights. Moral means ये मैंने किया, ये मैंने बनाया है, so that will be with you at the last breath of your life, क्योंकि वो आपने किया है, so वो आप बोल सकते हो. लेकिन when it comes to the monetary, वो उसके ही सब है, जो भी जंजाल है वो उसकी ही है पूरी लाइफ. तो वो जो कुछ भी मॉनिटरी थिंग आएगा तब सब कुछ आएगा कि भाई इन्होंने आपने अप्लाई किया, आपने एम्प्लॉयमेंट एग्रीमेंट में क्या था, आपने क्या.
So that means while signing your joining letter, you should carefully read that particular piece of.
But if you are
yes, otherwise
yes.
you will be in a big mess.
If you are focusing on that particular unique kind of the computer generated work, then you need to focus on that because they are paying you. So by that way you are giving the work.
For example, in the AI, I might have created my own bot, like own agent, and while switching the job, now company said that ये तो सब हमारा है, हमने जो किया वो that is fine. You have created the salary.
And mostly they are in the employment agreement, mostly they are covering this part. If it's a big companies and if they are aware about the IP rights, they are covering this. Now coming to the patents, so all the IP rights or especially the patents are the exclusive right, means we are excluding others. We have our own property, but we are excluding others to making, using of that particular research work or our brand value or whatever the IP we have applied. Then for the patent specifically 20 years is there from the first filing date. Every research work cannot be patented. There are some specific criteria are there that we need to first check it out and then we have to apply for the patent. So these are the three criteria. This is known as the patentability criteria. If our research work fits into this, then only we can apply for the patent. So it's a novelty. Novelty means in the very common language or the layman language, it's a new thing. Something will be the unique or the new. Then non-obviousness or the inventive step, and third one is the industrial applicability. So the novelty means if you have done something new or unique, that's why you are going for the patent, because you have come up with some new things. So that mostly that criteria will be fulfilled. Third one is also fulfilled because you have solved some problem, that's why you have come up with some new technology. So that it may be helpful for the industry and the society. So first and third criteria, to justify those things is little bit easier thing, but to justify the non-obviousness, that is the tricky part in case of the patents. So related to the technical advancement and economical significance. So whatever invention you have come up with that, if it having some technological advancement in that, and it having somehow it's not a technological that much advanced, but it gives you some economical benefits to the society, then also you can prove these things. Then coming to the trade secrets, it's a kind of the document we need to prepare, or the company, they are preparing one document, kind of the agreement or kind of things. They are write down everything in that, whatever they want to keep the secret in that, and they put those things into the lockers of some bank account, or very few people of that company knows about these secrets. This is the example of the Coca-Cola. In the Coca-Cola, only 2 or 3 people which are in the higher authority, they knows about how the ingredients are used in that, how they are making the Coca-Cola. And at a time, these 2 person also not meet each other, and they don't know who knows about these trade secrets. And it will be this document remains into the one of the country's bank, in another country. In that bank account, it will be there. Some person will go there, they check it out and come back, and in the very common format they will tell to the workers and everything how to make the things. So whenever it will remain secret, it will be protected under the trade secret. So these are the few things which you can protect by the way of the trade secret. One is the formulas. The best example is the Coca-Cola. Whatever things they have added into that, that is till the date it's a secret, and for that they have applied for the trade secret. Then the recipes and the cooking techniques in the KFCs, whatever they are using the 11 herbs into that, that is the recipe and the cooking technique they have protected under the trade secret. Then manufacturing processes in the Gorilla glass which we are using for the mobile phone, for that how they are making those things, it is protected under the trade secret. And yes, in the software algorithms, any kind of the algorithm which you are developing, those you can protect by the way of the trade secrets. Then what is the importance of the IPR? कब से ये बोले जा रहे हैं मैडम, क्या हो रहा है, इसका importance क्या है? What is the important for that? So one, as I told that, is the moral rights, right? Another is the monetary rights. Now how you can generate the revenue or the money out of this, right? So if you have a house, in the very common example, if you are taking, if you have a house, if you are giving this house as a rent, so you will generate the revenue out of that. Or you are selling those house, you are generate the revenue out of it. Similarly, this is also one kind of the property. If you have a property, then you can give the license of that, then from that you can generate, or you can manufacture by yourself and generate the revenue out of that. So by that way you can generate the money out of these IPRs. So one thing is for fostering the innovations. So if some patent is or any kind of the IP is applied for any person, any product. Let's for example, this design is already there. Then only another person think that okay, I have to come up with some new design. So and indirectly it's giving the pathway to the other person to do some new things. Then coming to the creativity investment, whatever the investment happen into the research work. If you are protecting and generating the revenue, then you can balancing those things, the investment as well as your monetary benefits, and the commercialization and monetization. If you have IP rights, you can license those things and you can generate the revenue out of that, or you can manufacture and sell your product by telling that this IP is applied on that. You can generate the revenue out of that. Then especially in the Indian scenario, if we can consider how the technology or the artificial intelligence will be protected into the IP rights, as such patents can, as such software cannot be patented as per the non-patentable rules or the Indian regulations. Patent regulation is there, but if you are combining your any kind of the software with the hardware, which is unique one. The hardware will, if you are running your software into the laptop, then it's not the unique one, because laptop is known since long. But if you are come up with some new hardware and you are combining your software with the hardware, then you can definitely apply for the patent. Second one is the copyright. As we have discussed, you can apply for the copyright for any kind of your computer generated work. Then the trade secret, as we have discussed, and the trademark protection. If you are applying giving any unique name to your product, then you can apply for the trademark or the brand name of that. These are some government initiatives for the AI and IPR. So in future we are predicting that some of the patent related regulation will be little bit not that much stringent, remains stringent, and the person can apply for the patent in the India also for the any kind of the software things. So they have come up with the one AI portal, national AI portal, as well as the one national policy has been drafted for the software products. And for in that we are predicting that in future software can be protected in the India, because in outside of the India any kind of the software you can apply for the patent and you can enjoy the monopoly for that. Okay, so this is all about the IPR and the AI. Thank you one and all for please for your kind attention.
So one question.
Sorry.
I have a question. Like,
Please.
how much it costs if I want to apply for a copyright? Because this is very new topic for us. कितना charge होता है? Like I love to write poems, right? But it's like ठीक है, मैं अपने शौक के लिए लिखती हूँ और मैं अगर उसको कॉपीराइट करवा भी लेती हूँ तो उसका मुझे क्या बेनिफिट मिलेगा? So like what are the costs usually?
Yes, so for the copyright for the individual person, it's a 500 rupees cost, very minimum cost they have right for the official fees. Now whatever your attorneys or the agents you are hiring, their professional fees will be different, but the official fees is the 500 rupees. Yes, just for the literary work, for the other cinematography, and for that the fees will be varies, but it not that much which cannot be bear by the individual person. And by that way you can take a legal action, or if you are publishing a book of all your poems, then also you can utilizing this copyright protection. Any other one have any question?
So one thing you mentioned that software patents available outside India but not in India.
Yes.
So that the person might have patent in US, but in India they can't.
Yes. Because under section 3K of the Indian patent law, they are strictly not allowing this as the software patent. If you are combining with the hardware, then they are allowing, or you have to apply for the trade secret or the copyright to protect your things into the India.
So that means if I can copy the Uber, can they can they take a legal action in India with the reference of patent?
No. If they have they have not filed the patent in India, they cannot.
But they have copyright, then
They will take the legal battle on copyright.
Yeah, there is another.
नेम से बहुत सारे लोग चला रहे हैं, तो कंपटीशन इज देयर, बट क्या है और मैं उसको अवेयरनेस होगा, उसको पढ़ना नहीं होगा, वो डिफरेंट थिंग है, लेकिन वो लेक ऑफ अवेयरनेस की वजह से दे आर नॉट जनरेटिंग मोर रेवेन्यू. अगर वो 4 एक जगह पे स्टॉल्स लगे होंगे, उसका एक रहेगा और 4 रहेगा, तो उसको प्रॉब्लम तो होगा ही, क्योंकि जो मॉनिटरी वैल्यू वो अर्न करेगा फ्रॉम 1 स्टोर और फ्रॉम द 4 स्टोर इज द डिफरेंस. एनी अदर क्वेश्चन? And thank you.